Hello and welcome to tip 3 of 5 tips in 5 days. I'm glad that you could join me or rejoin me if you're watching the recording. Each day or each tip will be covering a different subject. Tip 1, we were looking at dismissal and probation procedures. Tip 2 is about who works for you and on what contract. Tip 4 will be taking a look at preparing for an audit or inspection. And then tip 5 will be looking at making sure your managers have effective training in place and what you can do to keep abreast of the latest news. Now, today, tip 3 is all about understanding what strengthened employee rights might look like. And to do that, let's have a look at what the Labour government have said. Most importantly, the King's Speech, where the Employment Rights Bill was announced. That bill is designed to deliver the New Deal for working people in full and deliver on policies as set out in the plan to make work pay. If you're not too sure what the New Deal for working people is all about, you can take a look at the Labour website and there is a document on there which covers it all. A little bit of warning there for you in that was written whilst they were in opposition, not now that they're in government. So what was written then may not come into legislation now. So that's why the Employment Rights Bill, understanding that once it's issued, released even, is going to be so important. But let's have a look at some of the things that Labour have said. One thing that has been very well publicised is the banning of exploitative 0-hour contracts. Now, if you're in hospitality, employ students through holiday season, and many other organisations who use 0-hour contracts, this is going to be really important for you to be aware of and keep up to date on. Another change that they've announced is making parental leave, sick pay and unfair dismissal, protection from unfair dismissal even, available from day one of employment for all workers. And I mention all workers deliberately. And if you want to find out a little bit more on that, watch tip 2 from yesterday. It's important to note that unfair dismissal is currently set at 2 years. So the plan to make it from day one would be a significant change. However, there have been communications from the government that that's excluding probation. So probation hopefully will still be something that you'll be able to utilise as we move forward. We just don't know what the context of that will be, on what ability you have to put that in place in your organisation. The third, and I mentioned sick pay just now, but if we look at statutory sick pay, the intention is to remove the lower earnings limit so that SSP or statutory sick pay would then be available to all workers. Again, there's that word, as well as removing the waiting period. The waiting period means that the first 3 days of somebody's sickness, they're not entitled to statutory sick pay. They may get company sick pay if you pay that in your organisation from day one, but the intention is to make statutory sick pay available from day one. The fourth thing to bear in mind is making flexible working the default from day one for all workers. Again, all workers. There were changes in flexible working in April of this year. The intention is to take that even further. The fifth thing to be aware of is strengthening protections for new mothers from day one for all workers, from day one, by making it unlawful to dismiss a woman who's had a baby for 6 months after her return to work. So that means that a lady's been on maternity leave, she's returned to work, and 6 months after that return, the intention is you cannot make her redundant except in specific circumstances. So we'll have to wait and see what that says as well. And the final one that I want to mention right now, there are many others been announced, but updating of trade union legislation. And we know that the government have confirmed this month in August that the Strikes Minimum Service Levels Act of 2023 will be repealed. So that's a piece of legislation that the previous government put into place, and the new government will be removing that. So that will be working its way through all the legislative procedures that it needs to go through. So there's a fair amount in there for you to get your head around. But let's have a look at what that might mean for you in practice. Well, first off, is plan for the changing landscape. So there's a lot that you could do now to prepare. Have a think about what some of those things might mean for you. There might be some budgetary things that you need to bear in mind. Are you using 0 hours contractors in your organisation? And if you are, what might that mean for you? What changes might you need to put in place, or could you put in place now, or things that you need to be aware of as we move forward? Thinking about employee relations, do you have good employee relations, or are things not quite so great in your organisation? If not, have a think about what you could do to improve. That's whether you recognise a trade union or not. There are some things that you can do. For example, maybe put in a consultative committee in place. I've experience of that, and that works quite well, depending on your organisation, the size of business, etc., and your industry. Have you completed a review of who works for you and on what contract, so that you know what procedures will be applicable and to whom? If you haven't, have a look at tip 2, because that will give you some ideas on what to do there. Do you have the right procedures in place, particularly for disputes, and are you using them correctly? So that's something like a grievance procedure. What about your dismissal and probation procedures that are covered in tip 1? Do you have those in place, and those being used correctly and appropriately? In terms of sickness absence, then are you making sure that you complete return to work interviews or meetings? Do you have fit notes from your employees if they're off more than 7 calendar days? And do you get that before they return to work, so that you know what adjustments, if any, you need to make before they return? And are you referring them to occupational health if necessary? I mentioned the flexible working procedure changes back in April of this year. It's important to make sure that you've implemented those correctly in your business. And do you know who's applying for flexible working and when? Have you maybe reviewed your workplace to assess which roles could be right for flexible working? And if not, do you have some idea of why that might not be the case? And think about do you have an employee survey, what your engagement is like, the consultative committee I mentioned earlier to help with employee relations internally. So again, there's a lot to unpack there, and I appreciate that it's a lot to throw at you in one go. So please do take a look at the recording after. Those are my ideas. There'll be many others out there that you have. There might be other actions that you're going to put in place in your organisation. So it'd be great to hear from you, to hear what you're doing. If you've got any concerns or have got any questions on this, then please do call me, email me, or DM me in LinkedIn. Be very happy to hear from you and have a chat. Again, if you'd like to make an appointment just to chat through stuff, no obligation, doesn't need to go anywhere, then we can do that. I'll put how to do that in the comments. And join me tomorrow for tip 2, where we'll look at what inspection might mean for you. It doesn't end there. In September, I have 2 webinars, one on the 3rd, looking at the Employment Rights Bill, and one on the 17th, looking at the October 24 changes that will be coming in that you need to be aware of. And I'll put more details on how to register for those in the chat. So thank you for joining me today. Join me for tip 2 and have a great rest of your day. Bye now.